Hey folks, Ben Wittes here from the Mar-a-Lago bathroom studio. Welcome to this week's Trump's Trials and Tribulations. Undeterred by hurricanes, not stopped by a presidential election, not that is unfolding before our eyes. I have a bad set of sound in my ears. Why am I hearing myself? All right, I've got bad playback in my ears, and I don't know where it's coming from. Ah, that is why. All right. Um, Problem solved. Undeterred by presidential election campaigns that are unfolding before our eyes, and not stopped by anything else. The former president, keeps trialing and tribulating. We're going to have a special guest today. Joining us in about half an hour will be Harvard Law professor Jack Goldsmith, author of a very provocative New York Times op-ed criticizing Jack Smith for his mammoth filing the other week. Some of us may have some arguments with him about it. We're going to have a pleasant chat. Jack is, of course, one of my closest friends in the world and a co-founder of Lawfare. So we've got about half an hour before he shows up, and we are going to go over the news of the week, which has been piling up. One group of people who were very excited to see Jack's op-ed were Trump's lawyers, who Roger, I immediately cited it in a filing today. So bring us up to speed on the DC case.
Yeah, just about an hour or so ago, Trump filed his opposition to making the appendix, any part of the appendix, public. It was a two-page motion, so it was pretty simple. He opposes making any of it public, citing election sensibilities, election interference, the 60-day rule that Jack is going to talk about. And in fact, as his main citations are Ellie Honig and Jack Goldsmith, unfortunately in that order. But
Yeah, and we need to raise our voices in objection ever to citing lawfare second. And so memo to Trump's lawyers, when you cite a lawfare piece, it comes first.
Well, it was the New York Times piece that they
Yeah, but it's a
cited, right?
lawfare writer.
Okay, right, of course. Okay.
Oh, that's right. So anyway, but also of interest is that he said, if you are planning to make any of this public, give us notice because we may want to consider litigating, which I guess would mean seeking a mandamus to prevent this from coming out. So that's interesting. I mean, I think as it is, I wasn't really expecting a lot of it to become public. And I don't think the government was, from its previous filing, I didn't get the impression the government was trying to make a lot of it public. They were taking the position that the actual grand jury transcripts and the interview notes and all of that is non-public. They only used summaries and some quotations in the other thing. So I don't know if that's going to be a disputed issue. Yeah, so that's what today. Shall I go into some of the other?
So let's bring us up to speed. There's actually been a fair bit of action in the DC case while everybody was focused on that one mammoth filing. What else has been going on?
Yeah, they on October 1st, they filed, the government filed a surreply relating to Trump's additional discovery requests that he wants, says haven't been satisfied, and particularly those relating to the immunity question. And the government responded that he already had a great many of the documents he was asking for. And it was, and in fact, in some cases, this was the second time they had asked for them, and they had already been provided, and the government had already explained where they had been provided. But one of the issues that I thought I was interested to see what the response was that Trump wanted all of the DOJ's and the Office of Legal Counsel and the Solicitor General's past internal memos about immunity questions about relating to the president. For instance, there's been a lot of this in the context of civil cases, and they thought that this might present relevant information about whether certain types of revelations would be intrusive on the whether making certain acts subject to liability would be intrusive on executive functions. And that did not sound crazy to me. So I was interested in the response, and the response is simply that it's attorney work product, and they seem to be they seem to be pretty confident that the law does not allow these sorts of internal memos to have to be turned over. But that seemed to be the one sort of substantive thing to look for. How does Judge Chutkan respond? The other interesting thing was that they were very worried about more attempts at interlocutory appeals, the government. And so they were saying, if you're going to do what we ask, which is to not deny their motion, don't do it now. Do it in conjunction with your ruling on the immunity questions. Do it all at once. If he wants to appeal, let him appeal the whole thing. But we don't want multiple interlocutory appeals. Another filing was on December 3rd, and that was Trump's supplemental response basically to the developments in Fisher versus United States. They already had, you remember, a motion to dismiss on statutory grounds, and this is the more elaborate motion to dismiss based on Fisher versus United States, the request to dismiss the two charges that are based on 1512C2, the second count 2 and count 3. Count 3 is a conspiracy to commit 1512C2. Here, I'll be interested to see the government's response, because I thought at least part of this was also troubling. I mean, meaty, weighty. Remember,
and just a reminder for those who don't remember Fisher,
yeah,
and for whom 1512C2 is gibberish. This is the case with involving the obstruction statute, and the Supreme Court kind of narrowed the statute to say it has to be obstruction somehow involving the making of documents or physical evidence unavailable, or tampering with it in some fashion.
Yeah, exactly. And I'm sorry not to explain that. Yeah, it's corrupt obstruction of an official proceeding. And originally, the government thought it meant exactly that, and that you could corruptly obstruct an official proceeding by, sending a mob to obstruct it. And the government said, and the court said, no, it's got to be something involving impairing the availability or the integrity of documents or records or objects that are going to be used at the proceeding. So part of their point is, the government seems to be saying, well, if it's impairing, part of their claim is now, well, he was impairing the availability of the certificates that were going to be used, the certificates from the states that showed how the electoral slates had come out. And those indeed were, once the riot started, those were whisked away from the proceeding for safekeeping. So it did prevent the availability. What concerns me is that, the government in this brief does not accuse Trump of inciting an insurrection or inciting a riot. I've often wondered why, but they don't. And so parts of the proffer that we talked about last week seem to be saying that, but it never comes out and says Trump intentionally caused a riot. And if he didn't, how can you hold him responsible for trying to make these things unavailable? It may be that in fact he caused them to be unavailable, but for a crime you need intent. So this part concerns me. Now, it's true that there's an allegation that once the riot is in full swing, he issues that tweet at 2:24 p.m. That's well into the riot. They're already into the building. He issues a tweet that sort of pours gasoline on the fire. The Mike Pence didn't have the courage to do something or other. So maybe that would be sufficient. As far as the integrity argument, impairing the integrity of documents, we assume, and again, it'll be interesting to see what the government says when it files, we assume this relates to the false electors scheme, the creation of these, false certificates saying that people were duly elected when they weren't duly elected, when they weren't duly appointed, because their governors did not certify that they were that Trump in fact won those states. The response there seemed weaker, but it had to do with the fact that it's not clear that the certificates actually reached the floor ever. So I don't know if, but since the statute talks about attempt, I don't know if they need to reach the floor. They were sent to all of the appropriate places, the archives, the Secretary of State, the U.S. Court for the district of the state capitol, and so on. So I don't know, but I'll be interested in seeing that response. So I think those are the things that occurred. We're waiting for that reply from the government on Fisher will be next week, October 17th. And then the Trump's response to the motion to determine immunity, motion for immunity determination, and his motion to dismiss will be November 7th, just 2 days after the election.
So miles to go before we sleep
Yeah.
on this one. All right, let's talk Florida. A little bit less action there, the case having been dismissed and being on appeal. We got an 11th Circuit appeal, however. What's going on there?
Trump got an extension for his response to Jack Smith's brief. So that won't be due until November 15th, also after the election. Then the special counsel will reply around December 6th, and then oral argument will be set. That could take months. So that one is not on a short track. There was an amicus brief filed on behalf of Trump by Josh Blackman and Seth Tillman and a few others. But I don't know if we want to go into that or not.
Well, let's go into it. I mean, do they make any arguments that are substantively different from the ones that Trump makes?
Yes, they had already made one below, which Judge Cannon didn't give a lot of attention to, and then that had to do with arguing that Jack Smith is not only not what's called an inferior officer, which is what the special counsel calls him, and not a
Principal officer.
principal officer, which is what Steve Calabresi says he is. That was another amicus, and maybe Trump says that too. But he was a mere employee. And that he's being given too much power as a mere employee. But anyway, that didn't get much attention below. Then they've added at least two new arguments. One is that remember that the main argument is in that case, the one that Judge Cannon accepted was that there was no statutory authorization to appoint Jack Smith, and that the four statutes that the special counsel cited, and in fact that Merrick Garland cited when he appointed Jack Smith, were not apt. And one of the hurdles there was that in United States versus Nixon in 1974, the Supreme Court said that those same four statutes did authorize the appointment of the special counsel in that case, who was at that point Jaworski. And then there was a dispute about, was that a holding or a dicta? And so Blackman and Tillman say, whether the Nixon analysis is a holding or dicta, it is not controlling, and it should not be extended to today's context under today's statutory and regulatory framework. They say it was the proverbial ticket good for one unique ride only. And they develop an argument that the situation in Nixon was so unusual that we should not extend its precedence further.
So what is the schedule for the 11th Circuit? We now have the amicus briefs are in. Trump's reply is due
November 15th.
November 15th. And
And
I
then-
assume there'll be a reply brief, right?
That's right, December 6th.
Okay, and then the actual oral argument is not scheduled yet, or
Not
it is?
scheduled.
Gotcha. So yeah, miles to go in Florida, even assuming they dig Fort Pierce out from under a fair bit of water. Do we know anything about how bad the tornado was in the Fort Pierce area?
It was bad. People were killed. So I think four died is what I heard. So I don't know about, whether
The courthouse was
whether the
damaged.
building was struck or anything.
Okay. Georgia, we have not forgotten thee. Anna Bauer joining us from the doctor's waiting room studio, or the dentist waiting room studio. Tell us about what's going on in Fulton County.
Yeah, so we do actually have some action in Fulton County, or rather more accurately in Washington, D.C., because the action is happening at the Supreme Court. Mark Meadows, as Trump Trials and Tribulations listeners will recall, sought to remove his Fulton County state criminal charges to federal court. His state case that is before Judge McAfee is currently on pause while the disqualification of Fani Willis is being litigated at the Georgia Court of Appeals. But his litigation over this appeal of removal to federal court is ongoing. The 11th Circuit denied his initial appeal. And in that decision, again, as Trump Trials and Tribulations listeners will recall, the 11th Circuit said first that under the federal removal statute, former federal officers are not allowed to remove. Basically, that statute only applies to current federal office holders. And then second, even if they're wrong, and even if he could remove, that Mark Meadows did not have a sufficient causal nexus between the alleged acts and the indictment, and then the scope of his federal office. Basically, in this decision written by Chief Judge Bill Pryor, who certainly is a very conservative judge in most respects. He said that, there is no federal authority to interfere with state election processes as alleged in the Fulton County indictment. So Mark Meadows was not able to appeal that district court decision. It is now before the Supreme Court, in the sense that Meadows' team is trying to get the Supreme Court to take up the decision by the 11th Circuit and to hear the appeal. So this was a response in opposition to Meadows's writ for cert. And it's a very strong, as far as I read it, it seems to be a very strong brief in opposition. One of the criteria often when the Supreme Court is considering whether to take up an appeal, they consider whether there's a circuit split between the various appellate courts. On the first issue about the interpretation of the federal removal statute, the Fulton County District Attorney's Office makes the point that this is actually the first appellate court to decide whether or not to actually address the issue of whether or not former federal officers can remove after hearing briefing on the matter. Of course, there have been instances in which former federal officials have removed in civil or criminal litigation, but it is never actually, appellate courts have really never had to actually confront this issue head on. And remember, it's an issue that actually the Fulton County District Attorney's Office didn't initially raise in the briefing. It was not until the court said, I want you to address this, that the District Attorney's Office filed a supplemental brief on the issue. But then they go on to say on the second issue, basically that Mark Meadows gets it wrong in that Meadows's petition for a writ of cert had argued that the 11th Circuit applied a too strict of a test in deciding whether there was a nexus between the federal office and then the acts alleged in the indictment. That relates to an amendment in 2011 that was made to the federal removal statute, in which Congress added the terms for or relating to federal office. And that seemed to broaden the scope of acts that a federal officer could remove a prosecution from state to federal court. And Meadows's team had said that basically the 11th Circuit construed that language too narrowly. The district attorney's office says, no. Actually, they cited the case law in the 11th Circuit, where the 11th Circuit went with the much more broadened, expanded interpretation of the statute. And so, you know, Meadows is basically just misconstruing what the court said. And the court said, in no matter whether you portray it or look at it in the more narrow way or in the broadened kind of way post 2011 amendment, it doesn't really matter, because in either case, they would find that Meadows did not have a sufficient causal nexus. So I think it's a strong brief. There are some points that I'm not entirely convinced were necessary to include. For example, in the discussion around the policy of the competency of state courts to decide federal immunity defenses, the Fulton County District Attorney's Office discusses the fact that Trump himself decided not to remove his case to federal court in the Fulton County case. They over and over again kind of say, even the former president decided not to remove his case to federal court. And so that just shows that that state courts that do have competency to decide these immunity issues, because Trump has raised immunity in state court. I don't really find that to be particularly compelling, because of course, there are various reasons that a litigant could have for not taking certain steps, like seeking removal. In the case of Trump, we suspect, but do not know, that it has to do something with the meaning of officer of the United States, because you would kind of have to commit to, on the one hand, in the Anderson litigation around Section 3, you'd have to, say one thing, and then in the removal context, you'd have to say another. So there's some things that I think are weaker points of the brief, but overall, very strong brief from the Fulton County District Attorney's Office.
And what are we expecting schedule-wise on this? Again, I assume there's a reply brief and then the Supreme Court takes it or not whenever it feels like it.
That's exactly right. So it's about a month that there will be a reply brief, unless for some reason there's an extension. There's been various extensions in this cycle of briefing on the petition. But and then after that, after the reply, we will see what the Supreme Court does. So it could be a while until we know, or they could act promptly. But we do have one more cycle of a reply brief coming.
All right. Speaking of removal litigation, and I have to say, when Jack and Bobby and I founded Lawfare these many years ago, I never imagined that we would have a live stream in which we discussed 2 removal to federal court cases in one brief period. But we also have removal litigation in the Second Circuit, right? Regarding the New York criminal case. And so, Roger, what's going on? Who's removing what in New York, and why is the Second Circuit thinking about it?
I guess we actually have 3, because we've got Meadows' removal petition in Arizona, which is now on appeal to the Ninth Circuit. This is
we're going to rename Lawfare Removal Fair.
Yeah. And then, in the New York criminal case, Trump is at least scheduled to file a Second Circuit brief that's in New York. He tried to remove the New York criminal case for a second time after the immunity ruling, and that was denied, and he's appealing that. His brief is due October 14th, which I think is a holiday, so maybe the 15th. That may be Tuesday. I said it's due. I'm not sure why he's doing this, because Justice Merchan already pushed the sentencing off till after the election, but I guess maybe he hopes this will be a mechanism to push it off even further.
All right. And then finally, we have had an oral argument in the New York civil judgment, the $500 or $478 million judgment. This is normally beyond the scope of Trump's trials and tribulations, but it is a trial and tribulation that seems close enough that we shouldn't let a major appellate argument go by without thinking about it. Didn't go so well for the state AG, did it?
No, no. And this was September 26th. We actually, didn't discuss it last time because of the immunity filing. But yeah, no, it did not go well. It does not seem like the thing will survive in its current shape.
And what was the, what was the fundamental deficiency that the judges of the, or the justices of the First Appellate Division seem to have with the judgment?
I see Jack's here, so I will go quickly. I would say the things that the big problems that there were multiple questions, but the fact that there was no harm to lenders, and also the fact that these were private business transactions between very sophisticated business partners. So it was not consumer fraud, for instance. So and some felt that this statute was really to protect consumer fraud. Others felt that, no, it's okay because, the statute is supposed to be for deterrence and for play a prophylactic role. You don't have to wait till there's a catastrophe. You're supposed to try to promote honesty and integrity in the commercial marketplace. But a lot were concerned about, we need a limiting principle because this is and so I would say that is the, if it's struck down in its entirety, it'll be because of that. And if it's not struck down in its entirety, the size of the award will be limited for various reasons.
And just for people for whom the New York appellate system continues to be infinitely bewildering, if you are the loser at the First Appellate Division, can appeal part of the decision, right, to the New York Court of Appeals, but there's aspects of it that are unappealable. Is that right?
I think the Court of Appeals is not, it doesn't take up questions of fact. And I think it might not take up questions of mixed fact and law, but I don't really know how that works. It's the Appellate Division First Department, and the appeal will be to the Court of Appeals. But you're right, there's a lot of things that can't be appealed further.
All right. We are joined at this juncture in the narrative by Jack Goldsmith, who woke up sometime this weekend and decided to piss off as many people as humanly possible with a single op-ed in the New York Times. And so, Jack, I just
only people in your world, Ben.
Not
everyone.
I just want to ask, how negative has the reception been to this op-ed?
It hasn't been the worst I've ever received, but it's up there.
Yeah, all right. So
but that was not unanticipated, obviously.
I know you woke up and chose violence. So
I don't actually go ahead.
No, I'm teasing you. So walk us through the thesis that you articulated in this piece, and then I've got some questions for you about it.
Okay. The thesis was it built on the disclosure in the brief filed in the immunity case that was disclosed by the judge last week, whenever it was, 10 days ago. And the claim came in waves. The initial claim was that the brief on its face violated, was in tension with, clear tension with, I said, the 60-day rule that, as articulated by the Inspector General Michael Horowitz and as articulated by several former Justice Department officials in his Inspector General report and in other places, and that Smith should has, I think, a duty to explain why it's not doing so, given the high stakes context for DOJ of this prosecution and the absolute importance for the department of not appearing political and not appearing to try to impact the election. So that was the first part of the claim. And then I said that was especially important that he do that because the department has, and the executive branch has been remiss in complying with norms in these prosecutions. And I cited as evidence, building on your great post, Smith's rush of the immunity decision, which I believe has the appearance of violating the rule of intending to impact an election, and that this was especially bad because it came against the backdrop of President Biden on 4 occasions and Vice President Harris on 1 occasion violating executive branch norms about commenting on pending decisions in which they have an interest. And so basically, in this highest stakes context for DOJ and the first prosecution of a former president and a political opponent, when DOJ needs to be bending over backwards to comply and to assure the public that it's complying with DOJ norms, then it's failed.
All right. So I have two basic arguments with you on this. The first of which is I have never understood the 60-day rule to be about behavior in litigation. My understanding of it has always been that it's about investigative acts and disclosures, specifically search warrants, subpoenas, indictments. And that once something is in the jurisdiction of the court, it's kind of up to the court and you litigate it the way you would normally litigate it. And so my question is, when you say it's in tension with it, you don't actually say it's violating it. And so is your argument that it is, there's kind of a spirit of the rule that it's violating and that it's, and that they should, as a sort of prudential matter, have handled it differently, or is it sharper than that?
So let me just say, I've spoken to a lot of people about the 60-day rule, and I've read a lot of people's commentary on the 60-day rule. And what you just described as the 60-day rule is one version of the 60-day rule. Inspector General Horowitz, in his 2018 report on the Hillary Clinton matter in 2016, went through several versions. He said it was unclear. He said it was very important that, and he defined it in several respects much broader than you just did, to include disclosures that could affect the election, which is much broader than investigative steps. Several people that he quoted viewed it much more in those broader terms. There are some people who think the 60-day rule doesn't exist. I talked to a former prosecutor who says it doesn't exist at all. There's massive confusion here. Can I just clarify a few things?
Yeah, please.
There's the justice.
Take such time as the gentleman from Massachusetts may require.
So just to lay out a little of the confusion, I'm going to try to write this up soon. There's a manual, justice manual, that has a rule that says that the Justice Department is not supposed to act with the purpose of impacting an election or appearing to have that purpose. And that gets embodied in what is called the Election Sensitivities Memorandum that the Attorney General circulates every 4 years. The Inspector General, and some people think that's the only rule there is. That's written, and that's what it is, and that's limited to purpose, and it's not tied to 60 days, and it's not about impact, even though the title of the rule says it's about impact, and the rule itself says it's about purpose. There's so much confusion about this. But Horowitz described a rule, and several other people do, that's about impact on an election as you get close to the election. And it's not limited to investigative steps, at least in many versions of it. And he asked specifically 6 years ago, precisely because this was a problem in 2016. It was a problem, as you recall, in 2020, when Barr was being accused of possibly violating this. Chuck Rosenberg wrote a great piece for Lawfare saying it's bad that this rule is ambiguous because it can be abused. DOJ still did nothing in response to the Horowitz report. It's still an open matter, according to the IG webpage. So we don't know what the 60-day rule is, to be honest. And that's why I said it appears to violate it, because, and as I said in the piece, it's ambiguous and we don't really know what the rule is. My real point is that to a lot of people in this country, it looks like DOJ is acting very politically here. I'm not claiming that they are in this case. I said it's the appearance of it. And this is not about anything other than trying to help DOJ, which I think is really, really hurting itself by not clarifying exactly what the rule is, why and why it's complying with it. And they can't do that because I think anything they say is going to get them in trouble, frankly. It's going to be very hard because there's so much uncertainty about the rule. And that's what I worry about.
But they have said something, which was in the context of the case before Judge Cannon. In Florida, I believe Jay Bratt was asked specifically about the 60-day rule and said that the Justice Department's position was that it doesn't apply in litigation. Am I remembering that correctly? And if so, why is that not an adequate clarification of the point?
First of all, because it's not an explanation that explains why all of these other statements are wrong and why the Inspector General is wrong. And it could just be some opportunistic rule that they hide away in a transcript. But the real reason is it's not at all clear if you read that carefully that that's what he was saying. He was talking about, and the only thing that was included in the papers was the manual I was talking about. The judge brought up the 60-day rule. And then there's a garbled discussion about the 60-day rule that's completely inconclusive. And it's not clear if he's talking about the 60-day rule or the manual being limited to litigation. But even if he were crystal clear, and he said that the department's understanding is that it's only litigation matters and that we can do anything in 60 days, any kind of disclosure that's not a litigation step that looks like it impacts the election, no problem. That's the rule of the Justice Department. If that's their position, they shouldn't tuck it, which is not what the Inspector General thought. They shouldn't tuck it away in a garbled hearing transcript. They should explain themselves to the public. That's the point.
And as you may know, and as Roger mentioned at the top of the show, your piece features prominently in the Trump brief that was filed today, in response to which I assume they will have to do just that, right? I assume that, to the extent that they're now, that Trump is putting on the record that there's something inappropriate about what has happened, they'll have to respond to that. Is this litigation an appropriate venue for that?
I don't know. It was in the context of the Miami litigation or the
No. It was in the DC litigation in response to.
So basically, I don't think there'll have to be any response to it because the judge made clear that in her view, it's utterly irrelevant to her and it's not binding on her. DOJ has been very coy and not responding to, as far as I can tell by reading the papers, and not responding to Trump's claims about the manual mostly, a little bit on the 60-day rule. And they've tried to say as little as they can about it. And the judge said in one of the transcripts when this was raised by the Trump people, I'm not bound by it. You haven't convinced me that I'm bound by it, so it's not my problem, basically. So I'm not sure anything will come of that. I didn't read it. I heard about it. But I don't see why it will require DOJ to do anything unless it wants to. And I hope it does. I think they're going to have a very hard, if their position is what you think it was in the Miami litigation, then
that's how I've always understood the 60-day rule. But my understanding is admittedly not dispositive.
When you read the Horowitz report, did you think he was just crazy and that the several senior people he quoted were just crazy and reading it broader than that?
No, the quote that you used from the Horowitz report said investigative steps or disclosures. And I've always taken the word investigative to refer to modify both steps and disclosures. So like you wouldn't unseal an indictment in that window. I've also always understood it only to apply to named candidates, which this clearly that's not at issue here. So, but I agree with you. There are different people.
Yeah.
There are different people who have different interpretations of it. So
this is the point. That's the point, is that it needs to be clarified. It should have been clarified a long time ago. Now is not the time to clarify it because it's going to, unfortunately, if they clarify it now, it's going to seem opportunistic. This is why it's disappointing that neither the bar nor the Garland Justice Department responded to the IG's request.
So I want to throw out one other thing before turning to your second point, which involved Kamala Harris, which is, would it change your view of this if I said to you, actually, some of the premise off of which you're writing, which is the press's insistence that there are bombshell revelations in here, is actually like the press was just wrong about that. Like what there was a proffer of the evidence that was going to support an existing indictment. There's very little that's actually new in it except details. And so it hasn't hit the political landscape like a bombshell because in fact it's not. It's just a brief.
I don't have a view about that. And let me explain. I agree with you that in the round at 20,000 foot level, there were no new revelations. There were new details as far as I can tell. It was certainly covered in a very big deal way. The 60-day rule in one version of it is whether a disclosure could impact the election. And so the question is not whether there were new disclosures or not. The question is whether these disclosures could have been, and as I said in the piece, maybe DOJ thinks that these don't have a material impact on the election, and that's why they're in compliance with the 60-day rule. That would be a great thing to learn. But I don't have a view about, I agree with you that, whether the bombshell or not, it was a bombshell in the sense that it was on the front page of every
big news in October
in very extravagant terms 3 weeks before the election. Do I think it's going to have any impact on Trump's chances? I don't think it will, actually. And if that was the view of in some quarters it could help. If that was the view of the Justice Department, great. Let's hear why.
Okay.
That's my point.
I want to say one word in defense of Kamala Harris. As you criticize her in the piece for having observed during the debate that Trump was being prosecuted for national security crimes and election interference crimes. I yield to nobody in my sense that the president and the vice president shouldn't be commenting on pending litigation or investigations. But that is a simple, true fact about the public record. It doesn't put pressure on the Justice Department. It doesn't say the case is merited. It doesn't say it's no different from saying that Joe Biden's son is facing prosecution, which is also a true fact. And my question is that really a violation of a norm to articulate the fact that your political opponent, without commenting on the prosecution, is facing an indictment?
An indictment brought by your administration.
Sure. It's still just a public fact.
It's a public fact that in the context, she was using the prosecution brought by her administration under the supervision and with the many steps, the approval of, as we've learned, her attorney general, that it brought against Trump. And as I said, so yes, I do think that in that context, trying to use a prosecution brought by the administration, she was making the statement a mere fact in a way that sought to hurt her political opponent. So in fact, that was in many ways, if it hadn't happened in the campaign debate, if she just said it in commenting, it would have been a clear violation because she's commenting on the investigation being pursued by her Justice Department in a way that was trying to hurt her political opponent. I just don't see why that's not a core violation. As I said in the piece, there's an argument that this is a unique situation. She's a political candidate and anything's fair game. And she chose one value over the other. So that was my criticism.
Yeah, I gotta say, I really disagree with that. It seems to me that the choice to criticize your political opponent for any true reason, and in this political environment, let's include almost any untrue reason as well, is more norm than exception. And I don't think it is appropriate for her to say the case is merited, or I think that, you know, the Justice Department should pursue this case, or the Supreme. It's an interesting question whether it's appropriate to comment on the Supreme Court, but, you know, I don't think she should be talking about the behavior of the Justice Department or how the case should be handled. But I've got no problem with her talking about Donald Trump's alleged conduct.
That's fine. President Biden, I was paying close attention to this in the earlier debate, and as you can tell from this op-ed, I follow these issues. Biden was scrupulous during the campaign, when he was in the campaign, when he was talking about Trump's legal problems, not to mention the federal prosecutions against him.
Yes, and I'm not sure that was necessary.
But I'm just saying it was also not accidental.
Right. I think I'm sure that's right. All right. Roger, Anna, do either of you have questions for the witness before we go to audience questions?
I have one, which is, you know, I mean, I see a big difference between investigative steps and once a case is filed. And I take it I think we're in agreement. I mean, we don't know of any instance in which this rule has ever been used in an indicted case where the indictment came down outside the 90-day, 60-day period. We're aware of it coming up in investigative contexts. And investigative is ex parte, it's unilateral, and it often leads to nothing. Once it's indicted, it's adversarial, everyone's eyes are open, and you have lawyers. And this was indicted in August of 2023. It was 15 months ago. His lawyers, he has an apparatus, he has spokespeople, the defendant, they have been attacking Jack Smith nonstop with severe, I would say, they call him in papers, the Biden campaign surrogate. And that's some of the tamer stuff. This has been going on for 15 months, and it's obviously not just in papers. It's a campaign. And when the defendant is a candidate, anything you do is going to affect the election. You can, if you provide information, that can affect the election. And if you conceal information, that can affect the election. The question here was, do you file something that's going to include some probative evidence that suggests that this isn't, a vindictive prosecution, that there really is evidence out there? Or you can say, no, wait until after the election, conceal the probative evidence. Don't let the electorate see that. Don't let them see it until it's too late. Well, that can't be the rule. That we have the Sixth Amendment says a right to a speedy and public trial. And it says that's the accused's rights. Okay. But the Supreme Court has said that applies to society too. They have a right to a speedy and public trial. And it doesn't say they have a right to an artificially slow trial. And it doesn't say that you would conceal evidence from the electorate. And that's, there's an assumption and I think we saw it on the Supreme Court. There's an assumption that, being quiet, postponing everything until after the election is the natural state of things. I don't buy that. If the defendant is a candidate, whatever you do affects the election. once it's adversarial, and it came out 15 months ago, everyone's eyes are open, and you're governed by constitutional rules, not a DOJ rule about investigations.
Who is you, Roger?
Which sentence?
Who is you that's governed by the Constitution and not DOJ rules?
The parties.
I'm not talking about the parties. You gave the game away when you said it's bad not to let them see the evidence until it's too late. That's exactly what Jack Smith can't do. And
I'm sorry.
Let me finish, please. And most of your comments went to whether this was fair to Trump or not. Nothing in my piece. It was about fairness to Trump. I do think that rushing the immunity decision would never have happened consistent with normal defendant rights in other cases. But nothing in what I said in this op-ed has anything to do with fairness to Trump. And it's all about the Department of Justice and how the Department of Justice looks and what the impact of all this is going to be. And it's going to be a disaster on norms going forward. You make it seem like it's utterly irrelevant what DOJ does in the run-up to an election in terms of disclosing things that could look like it's impacting the election. And that's the way that the rule is framed in many circumstances. That's the key consideration, not fairness to Trump. And the key concern here is about the Department of Justice. And I just disagree with you. It's not about the Constitution. It's about DOJ norms. It's what I quoted Eric Holder as saying. This rules are about ensuring public trust that we're engaged in the appearance of fairness. That's what I want to make sure that DOJ is doing. And that's what my argument was about.
I want to just focus on one component of Roger's question, which was that inaction is a form of action here too. And let's say, for example, the Justice Department had filed this brief, but then requested of Judge Chutkan that she not unseal it immediately, out of deference to the 60-day rule. Why isn't that an action that could impact the election? Like, why is the assumption that when the Justice Department acts to release information? I mean, I'm reminded here of Comey's "before us were two doors, one was conceal and the other was disclose." There's something going on here too, right?
I don't think so. The rule's always been framed in terms of whether the disclosure, not the concealment, but the disclosure would be something that impacted the election. And the way it's talked about in the Inspector General report and by many other people is we don't do things in public if we think it would impact the election. We refrain during this run-up. That's the way the rule's always been framed.
So there's an act. So okay, no, that's actually fair. So you're not running away from the fact that inaction, there's a preference to inaction, even if it affects the election.
That's the way that version of the rule has always been framed.
All right, we have a question from Andrew. Andrew, please unmute yourself.
Yes, Professor, thanks so much for coming on and for your insights and defending this op-ed here. But I want to go back to a previous op-ed you wrote in August of last year, which was called "The Prosecution of Trump May Have Terrible Consequences." There, I mean, you talk about a number of different types of consequences, but you say Mr. Smith had the option to delay the indictment until after the election. So that's, I mean, this was long in advance of the 60-day run-up that you say the rule is designed to prevent, interference during. Are you just suggesting now that the entire case should have been pushed to avoid, a desire from Republicans for revenge or tit for tat or increased polarization? I'm just wondering if you still stand by that.
I did. That was not my argument. I don't have the op-ed in front of me. I did say that. But I think I made very clear in that op-ed that I thought that bringing the prosecution while it was a close case was entirely legitimate. I've never said otherwise.
And
I'm not sure it's going to be prudent in terms of its consequences, in terms of its structural consequences for DOJ and for the American polity and for our democracy. And that's what that op-ed was about.
yeah.
But
And
I've never said that the prosecution was illegitimate.
totally fair. I'm just wondering how to balance those concerns with the desire for accountability. I mean, do you have to wait until after an election to hold somebody accountable, like, period?
No, I didn't say that either. I do not believe that. I think that, if the trial had been brought early enough, it could have gone forward and it should have gone forward. And the way things turned out, it could not have gone forward in time. I mean, there are two prosecutions here. I've always viewed the documents case as an easy call and a no-brainer, and it should have happened. The elections case is a closer call about whether to bring it. It's a more controversial set of legal arguments. There are novel legal arguments. There are lots of difficult immunity issues. But frankly, what he did there was so much worse. And DOJ made its call. And I've never questioned the legitimacy of the call. I'm not sure I would have made the same call in terms of bringing the prosecution. But DOJ made its call, and I think that's just fine. And then the prosecution has to play itself out. It's very hard to get a case of that magnitude with the extraordinary array of novel issues that it involves, especially the immunity stuff, which everyone understated how serious those issues were. It was perfectly foreseeable that those were going to be hard issues, and it was going to take time to sort them out. But I don't have any problem with their judgment in bringing that case and pursuing it in the normal course.
All right. We have a question from Jeff, who asks, in what way can DOJ be insulated from a political pressure if official acts like control over the DOJ is now, he says, presumptively immune, but in fact, that's absolutely immune. So it's a good question. It's what's the, in an environment in which we strengthen political control, isn't it then also silly to expect a degree of political independence or investigative independence from DOJ?
I'm not sure I understand the question. Can you restate it? I don't really get it.
The question is, in what way can DOJ be insulated from political pressure if official acts like control over DOJ is now absolutely immune?
Oh, so I I see. I get it now. It's a great question. So listen, the Trump immunity decision has some extraordinarily broad language about the president's control over the Justice Department that frankly is not new from a unitary executive perspective. But DOJ independence was always a matter of norms, not a matter of constitutional law. And they've been complied with because executive branches have wanted them to be complied with since Watergate. And in a Trump world, when he comes in, we can expect those norms, what's left of them, to be totally disregarded. And that would have been true without the Trump immunity decision, but I think it's even more likely after the Trump immunity decision. Am I understanding the question?
Yeah, I think that's right. I mean, I think he's going to run roughshod over those norms, and the only mechanism with which to defend them is the impeachment process, which has been denuded of its content. Now,
I wouldn't say that's the only one. We'll see. I mean, he tried to run roughshod over them in the first term, and he was unable to. And he's going to be better prepared and better equipped this time. My guess is that it's going to be much harder to totally disregard them than even the most extreme Trump person thinks. But I think it's going to be much worse in the first term. It'll be somewhere in the middle. It's hard to get things done in DOJ if you're just going to be totally pushing them around from the White House. I just actually don't think it will work very well, but it's going to be ugly. It'll surely be ugly, and he'll certainly be trying much harder to tell DOJ what to do. No doubt about it.
Eric, the floor is yours.
So if someone is indicted prior to running for office, does that mean that running for office can effectively be used as a shield via the 60-day rule, et cetera? For example, if you get indicted in March, you file to run for office in May, knowing that the court process effectively gives you a 60-day set off. Do all court actions need to be stopped during that 60-day or just from the DOJ?
Well, we're only talking about a rule that applies to the DOJ. And I think the answer is, again, that's a little bit abstract and I'm not sure what you want to do in those 60 days. But under a prominent version of the 60-day rule, that would be correct. You could not take steps during those. It's, by the way, 60 days. It's not really 60 days. It's 60 to 90 days, or the rule becomes more
Right.
serious as we get
It's
closer to
some,
the election.
it's
Yeah.
some
Yeah.
block of time. But I don't think the indicted case that was indicted in that period, it would prevent the normal course of litigation in that. It's just a major new set of disclosures would be the more.
Yeah, exactly. That process could continue.
But even that, there are exceptions to. And of course, the famous exception is Rod Blagojevich, where I guess this may have been just after the election. But it was, the U.S. attorney at the time, who was Pat Fitzgerald, came out in the middle and said, he held a press conference and said the governor is engaged in an ongoing crime spree and we had to step in and stop it, and there was and so I think these are these are limited to non-exigent circumstances. And
Yes.
again, I do want to say that my understanding of it has always been that litigation is not that the litigation filings are not part of it. But
may I comment on this? Because you and Roger both made this point. So you're focusing on formalities, and the rule is, in many people's vision, not about formalities. It's about protecting the Justice Department from appearing to be political. That's the test. Are we doing something in the run-up to the election that appears to be political? And there's a lot of things DOJ could do that appears to be political in terms of could have an impact on the election. And so I agree with you that sometimes it's framed narrowly and it's formally followed, but you can't read some of those quotes in the IG's report and other people who've talked about the rule without seeing a broader concern that, look, we've got our integrity to protect here, and we've got to be very careful what we say and do in the run up to an election in terms of impacting that election. And so the formalities don't capture the rule.
all right, Jim, I think you have the last question today.
Thank you. Jack, the timing of your op-ed seems to me to be really unfortunate, given your stated purpose of asking DOJ to clarify this policy. It seems to me all it's done is to muddy the waters much worse than anything that either the judge or the parties have done.
How has it muddied the waters?
Well, I think it's given a lot of ammunition to the Trump side, certainly, to claim that, oh, here's an authority who is saying this was wrong, when it's not clear that it's wrong. It's clear that it's unclear.
Which is exactly what I said.
But I think done after the election.
If you're asking me,
why
do I
now?
worry when I write things how it's going to be used by politicians?
Well, you're asking the DOJ to worry about it.
Yeah, I am. I think it's vital that very soon they explain this. And it would be great if, I'm hoping that there's some memo in the public integrity section that goes through all the versions of what Horowitz said and said Horowitz was wrong, and all these people who said this are wrong. This has always been the practice of the 60-day rule. Look, we've papered that and Jack Smith has been consulting us all along, and we've had this norm established for 2 years. We just haven't told anyone, and it's all very clear, and here's the document. That would be the greatest thing. It would be great for the Justice Department. I hope that document exists.
Should we FOIA it?
I mean, I don't think it exists. That's the problem. And you're not going to be able to FOIA I mean, there are some public integrity people on the Smith prosecution going
Right.
over all this stuff, and you're never going to be able to get that.
We
But
are,
I will say, Horowitz was prescient on this. He said, this is a problem. It's going to continue to be a problem. You need to clarify this. It was a problem in 2020, and now it's a problem again, all because of all this uncertainty about the rule. And this highest stakes context is not great.
we are going to leave it there. Jack Goldsmith from the Arita building at the Harvard Law School.
Thanks, everybody.
Anna Bauer from the Doctor's Waiting Room studio, Roger Parloff from the Scott studio, and here Benjamin Wittes from the Mar-a-Lago bathroom studio. Y'all have a great week. We will see you next time.
Bye, y'all. Got to run. Thank you so much.
Thank you. Thanks for coming, Jack.
Thank you for having me.
We're still streaming.
The streaming stopped. It was just a second behind Ben. I believe.